Good morning, Mr. McLean. Or is there another public defender in there besides you today, Mr. McLean?
Mr. Haddad is with me.
Mr. Haddad, can you please send me your announcements?
He did last night. I saw him, but,
Not to Ms. Strong, he did not.
oh, I'm sorry. That's Ms. Strong talking. Yeah, we don't have video, so it's the voice.
Okay. Just a question, of how much time?
I think we can, just forward that.
Thank you.
I think it's up.
Casey Strong needs you to forward your announcement to her.
Oh.
Yeah.
Oh,
So, I don't know if she was on the list. Battle.
All right, good morning, everyone. Let's go ahead and get started. This is the state all-purpose calendar in the state court, Fulton County, Georgia. I'm Judge Melanie Williams. Today is January the 16th of 2016. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today. This particular proceeding is being broadcast over the internet as a live stream. It is also being recorded. That means any member of the public can log on and watch this proceeding. When I ask if you understand your rights, that is what I am referring to. All right, who do we have first?
Good morning, y'all. And this is going to be position number 4, Mr. Battle.
All right, thank you. Good morning, Mr. Battle. Your case is 23 CR 008415E. You're charged with possession of marijuana and giving a false name. Do you understand your rights today?
Yes, ma'am.
All right. Is this going to be a negotiated plea still?
I believe so, Your Honor. I haven't heard any different.
All right, thank you. Mr. Pierre Thomas, will you please, is this your case?
Yes, Your Honor.
All right, will you please give me a brief, very, very brief factual basis and the offer?
One moment, Your Honor. Your Honor, the factual basis is that on December 27, 2023, the law officer was on patrol at the location. They approached Mr. Battle on the driver's side door of another vehicle. They opened a bag. It had a I guess the smell of marijuana coming from it. The officer then approached Mr. Battle to confirm or dispel its suspicion of that was in the bag. Upon approaching Mr. Battle, he tied up the bag and stuffed it down his crotch area in his pants. The officer reported that Mr. Battle did have the marijuana odor coming from his person. He then detained and offered the opportunity to retrieve the bag from his, and offered him the opportunity to retrieve the bag from his pants, to which he produced 3 separate bags of marijuana from his crotch area, which totaled 10 grams of marijuana. He also, during investigation, gave the false name of Marcus Battle and a date of birth of September 5th, 1989. That is the indicia for the charges, Your Honor. The offer from the state as it relates to the charges, Your Honor, is a no pros on the marijuana charge, for the defendant to serve 12 months probation, to serve 4 days credit for the 2 days that he's already served. Looks like he was booked in on December 27th through December 28, 2023, and for the balance to be suspended. Nothing further from the state, Your Honor.
Thank you. Mr. McLean, was that your understanding? And do you stipulate to the 3 elements?
We do so stipulate, and yes, it is our understanding, Your Honor. We abbreviate that usually TS and BS, which is time served and balance suspended.
Understood. All right. I'm going to ask you some questions, Mr. Battle. Please raise your right hand.
14.
Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Get one.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time that would affect your ability to understand this proceeding?
No, ma'am.
Are you satisfied with your attorney's representation?
Well, I just got a quick question. Okay.
I'm sorry, are you?
Yes, ma'am, I just got a question to get through, ma'am.
You said you have a question? I'm sorry, I can't hear you.
Yes, ma'am.
Okay, thank you. Did anyone force you to take this plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking this plea?
No, ma'am.
And you understand you're not gonna have any further court dates regarding this charge?
Yes, ma'am.
And you understand you're giving up your right to have the state prove this charge against you beyond a reasonable doubt?
Yes, ma'am.
And you further understand that taking a guilty plea to any charge may affect other aspects of your life that either I or your attorney might not be able to anticipate, like employment or immigration or things of that nature?
Yes, ma'am.
All right, as to the charge of giving false name or other information, how do you plead, Mr. Battle?
Guilty.
I accept your guilty plea at this time. Is there anything additional?
Nothing
All
further
right.
from the state, Your Honor.
All right, best of luck to you. That concludes your case.
I don't need that. Yeah. If you got a question, ask the judge or ask your attorney. Excuse me, ma'am.
Yes,
Would it violate my probation, my federal probation misdemeanor?
I think you should ask Mr. McLean that. That's a question for him, okay?
You don't know?
Technically, it can. Oftentimes, the felony judge will look at a misdemeanor and gauge the seriousness of it. It is possible that it could,
Might, I'm not 100% sure myself. It might.
yeah, it could.
It's possible. That's what I was trying to explain, that by taking the plea, it may affect aspects that we're not quite sure at this time.
That would be up to your felony judge. Do you wish to stick with this plea or do you want to consult your felony lawyer for further information?
Yeah, I want to reset that, so I have my federal probation.
Your Honor, I think he'd like to withdraw his plea for the moment, reset it, consult his felony lawyer. I think he feels a bit nervous about it, and I think that would be the better course.
Okay, so we're gonna reset him 1 week. Is that sufficient, Mr. McLean?
Do you have a hearing coming up
I
on
got a hearing 26.
the 26th? If we could put it past the 26th, which is when he will see that judge.
Okay. Ms. Strong, is there a date past the 26th that still has slots that I could reset him to?
We can reset him to the 30th, Judge.
Thank you. So he'll be reset SAP 1:30. Hopefully we can resolve this matter then. All right, thank you.
Your Honor, I do have an inquiry.
Yes.
I see Antonio's iPhone on the gallery of videos. Is that Antonio Johnson?
Are you Antonio Johnson? The phone that says Antonio's iPhone? I don't know that they can hear us, Mr. McLean.
Yes, sir, I'm mute.
Yeah, I'm here. This is Mr. Johnson.
Okay, very good. Your Honor, in the case of Paris Johnson, I've marked it down as MH. And what we need to do at some point is a breakout room with Your Honor and the state, because that's, what's the phrase from TV, not ready for prime time? That one's
Okay,
not ready to go forward today.
okay, so that person will not be brought?
That's correct, Your Honor. I did interview that person and unfortunately, we could
Do
not.
you have a way to go into the breakout now there, Mr. McLean? Do you have a laptop or something so we can let Mr. Johnson go?
I
and he
haven't turned my laptop on, but I think I could borrow Mr. Haddad's.
Okay, can we do that quickly so that we can allow him to go? He's a witness in that case?
Mr. Antonio Johnson is one of the alleged victims, so is, well,
Okay, so if we could address that, let's so that he can leave, and then hopefully we can take Mr. Murphy's case right after that.
thank you so much. Okay, great.
Good morning, Your Honor. I'm sorry. Who all needs to be in the breakout room?
Mr. McLean doesn't have the laptop up yet. Ms. McLean, are you gonna be able to do that quickly, or do we need to hold on that?
About 60 seconds, I'll be running across the hall.
Okay, so it'll be me, Miss Champion, it'll be Mr. McLean's laptop, or maybe Mr. Haddad's, and then the screen that says Antonio's iPhone, Mr. Pierre Thomas, And who's with you as well today, Mr. Pierre Thomas?
It's gonna be Deputy Falk, but I think she is tied up currently.
She's not there yet, but and if Miss Falk is here, it'll be her as well.
Okay, thank you.
Thank you, Ms. Champion.
Okay. Thank you, sir.
Murphy, who's your clients?
Clarence Armstrong and Brianna Coleman.
Okay,
I got brief announcements on both.
okay.
Mr. Murphy, Brianna Coleman is here in at ACDC. You can see her on ACDC jail code Zoom camera.
Okay. Okay. Appreciate it.
All right, we're back. Is it possible for us to do Mr. Murphy's case?
Thank you, Judge.
Who's your client, Mr. Murphy?
Judge, the first one I have is Clarence Armstrong, and I advised the solicitor's office on Friday that I was at the Fulton jail, and he's now at Grady Hospital. So if we could reset that out a week.
Okay, so he's not present, so we'll reset SAP 123.
And the second one is Brianna Coleman, Judge. She's over at city facility, and I'd like a reset for 2 weeks. I need to speak to her felony attorney as well as go see her
Okay.
on.
Is Ms. Coleman at ACDC?
She is. I believe she's on the camera this morning.
Okay, Ms. Coleman, I just want to make sure you heard that. Your attorney is resetting your case 2 weeks so that he can confer with your felony attorney. So your case will not be addressed today. The reset date will be the 30th. All right?
Thank you, Judge. That's all I have.
All right. Take care, Mr. Murphy. Have a great afternoon.
Thank
Bye-bye.
you, Judge.
All right. Who do we have at courtroom 2 now?
Your Honor, can we go to the probation calendar? He has a private attorney on. The name is Nicholas Richardson, position 7 and 8 on the probation calendar.
Okay, give me one moment. Let's see. And I don't have my, oh, here it is. Hold on, give me 1 second. And who do we have from probation today? Who's my probation? Is probation on the screen?
Yes, Your Honor. My apologies.
Oh, there you are. Officer Brooks, can you raise your right hand?
Yes, ma'am.
Do you swear and affirm the test? And I'm gonna place you and the defendant under oath. Sir, will
Okay.
you raise your right hand as well? I'm gonna place you both under oath, just for the limited purposes of this hearing. Do you swear and affirm the testimony you give today be the truth to the best of your knowledge under the penalty of perjury?
Yes.
Do you so swear as well, sir?
Yes, ma'am.
All right. Give me one moment. Let me read your case to you. Oh, Mr. Honore, good to see you.
Good to see you, Judge Williams. How you doing?
I'm wonderful. Long time. We need to catch up. All right, let's take up your client's case. Give me one moment. And he's position 7.
Yes, position 7 and 8.
7 and 8. So, but 8 is just an FTA. Okay, Mr. Richardson, you're here for this case, 21 CR 003658Y. You were charged with disorderly conduct back in June of 2020. Officer Brooks, what is your recommendation? Let me explain this to you first, sir. What's going to happen is I'm going to first listen to Officer Brooks for the recommendation. Then I'm going to hear from your attorney, and then we'll decide how we're going to move forward to resolve your case, okay? All right, Ms. Brooks?
Yes, the recommendation from probation is to continue on probation and to give him a deadline to complete the condition of 30 days.
What was he supposed to do?
He was supposed to, give me one. He was to complete an anger management program.
Okay, 1 week. How long? How long was the course he's supposed to take?
1 second, and I'll tell you how many hours.
Did he
He's
start
supposed to complete a 12-week program, Your Honor.
I don't think he's gonna be able to do 12. Did he do any of it?
Your Honor, he reported to probation January the 24th of 2023 and then never returned, never reported or anything.
Okay, well, if he's supposed to do 12 weeks, I don't think he can do that in 30 days. How much time remains on his probation?
He has 166 days remaining on probation, Your Honor.
Okay, so he could potentially finish it. He just needs to get engaged within 30 days.
Correct.
Okay, understood. All right, Ms. Honore, any objection to that, allowing him to continue on probation and complete the requirements?
No objection, Your Honor.
Okay, so Mr. Richardson, you're getting a second chance. Essentially, what's going to happen is this will be reported as a probation violation. You have 30. I'm actually going to require that you get engaged within 2 weeks and begin starting these requirements so that you are able to finish these courses on time. You understand that? We could have chosen to revoke your probation, but we're allowing you to finish. So take that very seriously. Work with your attorney to start those classes, okay?
Yes, ma'am.
All right. That if you don't have other holds, you should be released shortly. All right. Best of luck to you. That concludes your case, Mr. Richardson. And Mr. Honoré, does that conclude your business before the court today?
Nothing further, Judge William. May I be excused?
Yes, you may. Take care. Have a great
All
day.
right.
Bye-bye.
You too.
All right. Who do we have next?
Next, Your Honor, probation, this is gonna be position 3 and 4, Mr. Michael Cosby.
Okay, Mr. Cosby, your case, you're here for an FTA as well, but your underlying case is 23 CR 00429-3J. You were charged with disorderly conduct, public drunkenness, and a charge I will not sound. Officer Brooks, you are still under oath, but let me put Mr. Cosby under oath. Please raise your right hand. Do you swear and affirm the testimony you give today be the truth to the best of your knowledge under the penalty of perjury?
Yes, ma'am.
All right, I'm gonna hear from Officer Brooks and then I'll hear from your attorney and we will figure out how we're gonna resolve your case, okay? Officer Brooks, your recommendation?
The recommendation for this one, Your Honor, is to continue on probation and complete evaluation within 30 days.
Okay. And any objection to that?
No, Judge, we respectfully request the court to follow the recommendation.
All right, Mr. Cosby, I am gonna follow the recommendation of Officer Brooks. We're gonna allow you to continue on probation. It will be reported as a violation, however, but you must get that evaluation done within 30 days of today. You understand that?
Yes, ma'am.
All right.
So,
Can you what? I don't want you to say too much. Perhaps you should ask your attorney the question, but what would you like to tell me?
well, she asked me she told me, Ms. Harris told me to go to Grady to get an alcohol evaluation. I went to Grady. Grady don't do that alcohol evaluation. So what I did, I went to Mercy Care and got an assessment. So I got that paperwork in my book bag at my police property. So all I have to do is just go get the doctor results and take the probation. And if
Okay.
that work is
So
good.
take what you have and bring it to probation and let them see if that is sufficient, okay? It sounds like you're trying to get it worked out. Please continue to try, okay?
Okay, thank you.
Thank you.
All
Judge.
right, thank you.
I apologize. Who was this that we just did?
He was Mr. Cosby on the probation calendar.
Thank
I
you.
think he's 3 and 4.
Yeah, he was 3 and 4.
Next is position 31 and 32, Mr. Thompson. This medical.
Okay. And what is the announcement for this case?
Mr. Thompson is going to be a plea, Judge.
Okay, is it negotiated?
It is. I submitted the paperwork last week.
Okay, understood. Mr. Pierre Thomas, can I please have the brief factual basis as well as state's offer?
One moment, Your Honor, I'm pulling it up. Your Honor, as it relates to case ending in 4397E, charges being obstruction, certain acts. The brief factual basis is that the defendant remained on the property and continued to drink Vintage Chardonnay Chardonnay after being told multiple times to leave the Ashby train station located at 65 James Joseph E. Lowry Boulevard. The defendant resisted arrest when detained. The offer from the state as it relates to that case is on count 1 for the defendant to serve 12 months probation, a concurrent to count 2 for him to serve 32 days in custody, credit for the 16 days that he's already served, for the balance to be probated, for him to pay a $300 fine, for him to stay away from that MARTA station located at Joseph E. Lowry, and for him to have no alcohol, drugs, or weapons. As it relates to count 2, Your Honor, As it relates to count 2, 12 months probation, 32 days to serve, credit for the 16 days that he served, for the balance to be probated, again, to stay away from that MARTA station, for no alcohol, drugs, or weapons. As a total, Your Honor, it's 12 months probation for him to serve 32 days in custody, credit for the 16 days, for the balance to be probated, for him to pay that $300 fine, and for him to stay away from that MARTA located at 65 Joseph E. Lowry Boulevard and have no alcohol, drugs, or weapons.
All right, and that was your understanding, Mr. Haddad. Do you stipulate to the 3 elements?
We do, Judge, and we just ask the court to follow the negotiated plea.
All right, Mr. Thompson, please raise your right hand. Do you swear and affirm that in case 21 CR 004397E, in which you're charged with obstruction and committing certain prohibited acts, that you will tell the entire truth for the limited purposes of taking a plea today?
Yes, ma'am.
All right, you can put your hand down. Did he also hear his rights? Mr. Thompson, I'm not sure you were on the line when I read your rights. You have a right to remain silent. You have a right to an attorney. And I'm conducting this hearing over the internet today, which means any member of the public can watch. Do you understand that?
Yes, ma'am.
Oh, thank you. All right. I'm going to ask you some questions to make sure the plea that you're taking today is entirely voluntary. All right.
Yes, ma'am.
Are you under the influence of any drugs or alcohol at this time?
Don't do it.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you are satisfied with your attorney's representation?
Yes, I am.
And you understand you're not going to have any further court dates regarding these charges, that you are giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you further understand you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you understand that taking a guilty plea may affect any open cases, probation, employment, or other things your attorney and I may not be able to anticipate?
Yes, ma'am.
And do you understand the requirements of this and the stay away locations?
Oh, yes, I understand. Yes, ma'am.
Oh, and the fines you have to pay, you understand that as well?
Yes, ma'am. Yes.
All right. As to the charges I previously listed, Mr. Thompson, how do you plead?
Guilty.
I accept your guilty plea at this time. Is there anything additional from
No,
the state of defense?
Nothing further from the state, Your Honor. And
Mhm.
just want you to know that we will be processing the no pros on position number 32 in conjunction with this plea.
All right, thank you. And Mr. Haddad, were you saying something?
No, I said nothing else is needed. I apologize, Judge.
All right, thank you. Best of luck to you, Mr. Thompson. That concludes this case.
Thank you, Judge.
Hey, are you asking a question?
Oh, yes, ma'am. I was asking about the $300. I just have no problem paying it. I was like, does that include the probation fees, or is that the probation fee or probation fee plus?
Probation fees will be additional.
What's that?
There will be, that does not include your probation fees.
Okay, yes, ma'am. Okay.
All right. All right, best of luck to you, Mr. Thompson.
You go to Joe Court's iPhone, Your Honor?
Okay, and who do we have there?
We have position number 24.
All right. I'm sorry, give me a second. Are you Javon Farr?
Yes, ma'am.
All right, Mr. Farr, your case is 23 CR 005879G. You're charged with battery. You have a right to remain silent. You also have a right to an attorney today. This proceeding is being broadcast over the internet. Do you understand your rights and how I'm conducting this hearing?
Yes, ma'am.
All right, and the announcement for Mr. Farr?
Your Honor, I'm handling this case. It's a negotiated plea.
All right. Thank you. And Ms. Falk, if you would very briefly give me a factual basis and the state's offer, if this is your case. Good to see you this morning.
Good to see you as well, Your Honor. I am going to start with the plea recommendation, so that will give me time to pull up the factual basis. The plea recommendation is 12 months, and that is with 60 days to serve, credit for time served, 4 days. That is going to be from September 30th to October 3rd. There's also, we're asking for no further contact with Miss Key, Shannon Key, as well as no possession of any firearms, FVIP, and 40 hours of community service. We would, at the end of our recitation, brief recitation of facts, like to sound from Miss Shannon Key. As to the facts of this case, this incident happened on September 30th of 2023. This was let me see, and it occurred at 159 Forsyth Street Southwest. The defendant punched Miss Shannon Key in the face after a verbal argument. That is all from the state. And there was injury to her, lacerations and blood on the right side of her face. And this happened at 183 Forsyth Street, where a bystander called police because he saw the defendant close-handedly punching Miss Key on the right side of her face while walking in the street. That's all for the state, and the state would ask the defense to stipulate as to factual basis, venue, and identification for the purposes of the plea.
You so stipulate, Mr. Haddad?
We do.
All right, I am sounding for Ms. Key at this time. Is Ms. Key present and wishes to make a statement? Okay, hearing none. Mr. Farr, I've already, did I place Mr. Farr under oath? I believe I'm gonna place you under oath. Mr. Farr, please raise your right hand. Do you swear and affirm the testimony you give today be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. I'm gonna ask you some questions to make sure you are taking a voluntary plea today. All right? Did anyone force you to take a plea today?
No, ma'am.
Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
And you understand you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you further understand you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand that by taking a guilty plea, it may affect other aspects of your life that we may not be able to anticipate, such as employment, immigration, probation, other things of that nature?
Yes, ma'am.
And I did not do the calculation, Ms. Falk or Mr. Haddad, but how many additional days will he have to serve at the Fulton County Jail?
He has served 4 days so far, so that would be 26 days, and it's up to the jail to give the 2 for 1.
It's 2 for 1. All right, understood. You understand that there is some additional.
Sorry, excuse me, Your Honor, 56 days. My apologies.
I know what you meant.
Served, thank you.
I know what you meant. You understand that there will be some additional time you will have to serve at the Fulton County Jail. Upon your release, you'll have to complete 40 hours of community service, a family violence intervention course, and have no contact with Ms. Key, as well as have no weapons. Do you understand that?
Yes, ma'am.
All right. As to the charge of battery, Mr. Farr, how do you plead?
Yes.
All right. I accept your guilty plea. Is there anything additional?
No, ma'am.
All right. I don't hear anything from either attorney, so we'll believe that your case is concluded at this time. Best of luck. We don't want to see you back here. All right, Mr. Farr? Take care.
Good morning, Your Honor. ACDC, we have before you position 11 and 12, Jada Wheeler.
All right. Thank you. Good morning. Let's see. Papers are hoping to be out of order. All right, Miss Wheeler. Oh, is she 11 and 12 on probation?
That's what I was about to ask, because she's not 11 and 12 on the main calendar.
She's not 11 and 12 on this calendar. Let me look.
It is probation, Judge.
Okay, Miss Wheeler, you're here for an FTA, but you're also here for your underlying case 23 CR 002261G. In that case, you were charged with simple battery in a public transit station and criminal trespass. I'm going to ask you to raise your right hand, okay? Do you swear, will you raise your hand, please, Miss Wheeler? Do you swear and affirm the testimony you give today be the truth to the best of your knowledge and under the penalty of perjury? All right, I'm assuming you're saying yes. And do you understand your rights today? All right. Officer Brooks, you are still under oath. Will you please give me your recommendation as to how we should resolve this case?
Yes, Your Honor. Probation is recommending that Ms. Wheeler be allowed to continue on probation, but that she also is required to enroll in her program within 30 days.
All right. And what was she supposed to do?
She was supposed to complete an anger management program.
Okay. And how long was it? And how much time does she have on probation?
Her anger management program is for 2 weeks, and she has 152 days remaining.
All right. Mr. Haddad, was that, do you have any objection to allowing her to continue on probation and take the courses she's supposed to take?
No, Judge, that would be our request.
All right. Ms. Wheeler, we're gonna allow you to continue on probation at this time. You need to make sure that you report to probation within 30 days of today. Understand that you are being given a second chance. However, this will be reported as a probation violation. Please take this seriously and engage in the classes so that you can complete the requirements, okay?
Yes, ma'am. Where should I report to?
Do you have the address for probation?
I don't, ma'am.
All right, Ms. Brooks, I'm not sure she can even has anything to write it down, but can we give it to her?
Yes, it's 132 Mitchell Street Southwest, Suite 2A, right across from the courthouse.
Right outside, right outside where I'm at.
Not outside the jail, but outside the courthouse.
Okay.
But perhaps somebody before you release, Officer Milton, perhaps you can
Yes.
give her that address. I would
Yes.
appreciate it. They'll
Would you
give you
please-
the address, okay?
Would you
Your
repeat
Honor.
it again?
132 Mitchell Street, Suite 2A. I have it, ma'am.
Your Honor.
Yes, Ms. Brooks.
Yes, did you put on there for her to have it completed in 30 days or start?
No, I said report within 30 days.
Yes, Your Honor, but I'm asking, can you put that stipulation on there so she can get it completed?
How long I'm sorry, you told me it was, she had to do how many weeks?
2 weeks.
Okay, that's fair. You have 30 days to get it done, all right?
Yes, ma'am.
So my recommendation is that you report almost immediately, all right?
All right, ma'am.
Judge, I apologize. Just to be clear, my understanding is that she's got 30 days to enroll, or is that court's request is that she complete?
Well, probation is actually asking that she actually finish it within the 30 days, and she only has 2 weeks to do. Do you have any objection, or are there circumstances, Mr. Haddad, that you're aware of that would keep her from being able to do that?
No, Judge, except, she has 152 days left. The recommendation that I received from probation is that she enrolls in anger management within 30 days, which is what I communicated to my client. I did not tell her that the offer.
That she would have to finish it within 30 days. Okay. Ms. Brooks, was there a specific reason for that request? I am requiring her to report within the 30 days. Is there a reason that you're asking for her to finish it in that same period that I might consider at this time?
Yes, Your Honor, it is.
What's that reason?
The reason that I requested it is because she has not, since being on probation, she wasn't reporting at all. And so I just have a concern that once she shows up the first time, that she may, we might not see her again after that, after 1 or 2 times, because she didn't report previously.
Okay. I think Ms. Wheeler understands the seriousness now that she's been picked up at least once. So we're just going to require that she report, but I won't require that she finish it within the 30 days. Ms. Wheeler, please understand that you do need to get it done, and probation is not looking to give you more than this 1 second chance. So you need to report as required and take the class. And it is my recommendation, even though I'm not going to order it, that you finish it in the 30 days. Okay? Ms. Brooks is looking for you to finish it on time. She's not playing. All right. All right. I believe that concludes your case at this time. Ms. Wheeler, best of luck to you. Okay.
Your Honor,
Yes.
I see that Mr. Jacoby Hudson is on. He's on for Xavion Kelly. Xavion Kelly is on our pull list for court, but he was not on the calendar. So I don't know if there's an add-on calendar for Mr.
Okay.
Xavion Kelly.
What was the name of the person? I'm sorry. What's the name?
Xavion Kelly.
Ms. Strong, can you tell me what happened to Mr. Kelly?
He is on the add-on calendar that, it's two positions that are on the add-on calendar. I'll send it to you, Norris, if you have not received it. Judge, Williams, did you receive it?
I did not receive an add-on calendar.
I was not aware of an add-on calendar either, so I have no recommendation on this
I
case.
think they were reset from Thursday's calendar.
Ah, okay.
So I will send it out and just.
Thank you.
I appreciate it. Thank you. And if it's a reset, then the offers had already been sent out previously.
Mr. Kelly is a reset from. Yeah, yes. From,
And
if
Mr.
Thursday
Hudson-
was the 11th, that it was reset from the 11th, whatever day that was. I'm sorry.
Okay, Mr. Hudson, what is the announcement for the cases?
Your Honor, I'm gonna ask for a reset anyway. I'll get with Ms. Falk. Ms. Falk, I didn't even know that you was even the assistant solicitor on the case. But Judge, I'll just ask for a reset. I'm also dealing with another matter for Mr. Kelly, so 1 week reset shouldn't be a problem.
I had a feeling we were gonna reset it anyway before we went through the trouble of setting out the add-ons. All right, so can we reset it to, is there room on SAP 123 still, Ms. Strong?
Yes, ma'am.
All right, reset 1 week SAP, January 23rd. And Mr. Hudson, does that include your business?
Yes, Judge, and I got my entry filed and everything is going down the pike. And Ms. Falk, just like old times, I'll reach out to you, okay?
All right. Can you do me a favor before you head out and put your email in the chat so I can send you the recommendation?
All right, I got you.
Thank you.
All right, take care, Mr. Hudson. Have a good day.
All right, you too, Judge.
Position 21 and 22, Mr. Nystrom, medical.
All right, Mr. Nystrom, your cases are, one is an FTA. The underlying case is 23 CR 005763H. You're charged with theft by taking. Do you understand your rights today?
Yes, ma'am.
All right, and what is the announcement for this case?
Number 21.
I apologize. Who is this?
21 and 22, Nystrom.
Your Honor, our announcement has been that we need to ask the state for a global offer because there's another case. So if it's too late today to grab the other case up.
What is the other case? Do we have the CR number? Are we aware of what the other case is?
I didn't see it in the computer last night, no.
Okay.
And Your Honor, I'm looking for the other case because I wasn't aware we had a second case. So let me go through and see if I can figure out which one it is.
Right, and it's possible it might not be in your office, so that's another possibility.
Oh, well, there's that.
Because I'm showing his other 23 CR case with us is closed. Now he does have a 23 CP 222492 from October 7th for felony possession of tools, criminal trespass, and theft by receiving. Maybe that's the one you're referring to?
That probably is. So what we need to do is I need to, like similarly to some other cases, we need to consult with the felony attorney assigned to it to make sure it's okay to go forward with this. So if we could set that 1 week, this is.
All right, we're resetting his case as well.
Yeah, this is a case having to do with an electric scooter. One of those e-scooters. I think they're green.
Okay, so we are resetting this matter. Mr. Nystrom, we will not be addressing your case today. Your attorney needs to consult and consider some things regarding your other case that's open. So we will be resetting your case 1 week. All right?
All right.
All right. Best of luck to you. You have a question?
Come on.
That's similar to our announcement already made in number 23. That's the same reason.
Okay.
While I'm at the microphone, I wondered on number Number 10, I need somebody from the state to call me on the telephone and give me a clarification of the offer. I wasn't
Okay.
sure what the offer was.
I can give you a call. Can you,
Yeah, it's
let me
20,
know which,
yeah, it's 612-2392.
2392.
Thank you.
Your Honor, can we go to Alpharetta Jail? In that position 1 and 2, Mr. Christopher Bell?
All right, that's not Mr. McLean's case, is it?
No, that's Mr. Haddad.
Position 1 and 2 on the probation calendar?
Yes, ma'am.
Okay. All right, good morning, Mr. Bell. Your cases are, you have the FTA, and then you're here for 19 CR 0009299Y, in which you were charged with obstruction. I'm gonna place you under oath. Can you raise your right hand? Mr. Bell, can you hear me? Can we mute at medical? Can we mute medical? Mr. Bell, are you able to hear me? All right, can we unmute at the Alpharetta Jail? Are you Christopher Bell?
Yes.
All right, Mr. Bell, please raise your right hand. Do you swear and affirm the testimony you give today for the limited purposes of dealing with your probation case will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. Officer Brooks, you're still under oath. Please give me your recommendation for how to resolve Mr. Armstrong's case.
Yes, Your Honor. His officer is recommending revoke.
All right. And I'm assuming you object to that, Mr. Haddad.
Yes, Judge. I think the request is to revoke the balance, and it's 48 days left, if I'm not mistaken. At least that's what was communicated to me. Judge, on behalf of Mr. Bell, I would just ask, he's been in custody since January 2nd of this year on this probation violation. He does not have any new charges that I'm aware of. This is a case from 2019, Your Honor. He did enter a plea, though, in 2022. So even though it's a 2019 case, he didn't plead out until about 2 years ago, Judge. I would just ask the court to consider just revoking and closing it out to time served, Judge.
How much additional time what was he supposed to do, Ms. Brooks? Officer Brooks?
Yes, Your Honor. He was instructed to complete a drug and alcohol evaluation and to complete any treatment recommended after the evaluation was completed.
And he didn't do that?
No, Your Honor, he did not do that.
And he has he only has 48 days left?
Yes, Your Honor, he did not report to probation.
At all?
Nope.
Is there a reason he didn't report at all, Mr. Haddad?
I mean, not a legal reason, Judge, no. I know he was struggling with employment, but again, that's not a legal reason. He ended up working as a chef, Judge, but I don't really have anything,
And how much time did he serve on this charge?
So, Your Honor, he entered a plea back in 2022. Had spent 9 days initially when he entered a plea. And of course, he's been at least on probation, was supposed to report, he did not. But this time around, he's been in since January 2nd, which puts us at 14 days. So he did initially 9 days and now 14 days on this case, Judge.
I'm thinking. All right.
Your Honor, he has a hold for DeKalb County also.
Oh, okay. Thank you, Ms. Tyson. All right, I am gonna follow the recommendation of probation at this time. I am gonna revoke his probation. I did consider all the evidence before me. All right. Is there anything additional?
No, Judge.
All right. Best of luck to you, Mr. Bell. That concludes your hearing at this time.
Your Honor, I'm going to stay with the probation calendar, and this is going to be position number 5. And position number 6, Mr. Matthew Reed.
All right, Mr. Reed, your case is 23 CR 001136C. You're charged with obstruction and possession of drug-related objects, and of course, you have an FTA, I believe, or you have a probation violation. Please raise your right hand. Do you swear and affirm the testimony you give today for the limited purposes of dealing with this case will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right. And do you understand your rights today and how I'm conducting this hearing?
Yes, ma'am.
All right. Officer Brooks, your recommendation?
Yes, Your Honor, we're recommending that he continues on probation and that he be ordered to complete his condition within 30 days.
All right. What was he supposed to do?
A drug and alcohol evaluation and any recommendation made out of it.
All right. And I'm assuming you have no objection to that, Mr. Dodd? I mean, sorry, Mr. McLean. Or is it Mr. Dodd? It's hard to see in that little corner.
No, this is Mr. Haddad, Judge.
Okay, Mr. Dodd, any objection to that?
Judge, initially I would have said no. My client just spoke to me, and I was wondering whether the court would consider essentially revoking 30 days and just closing out the case, Judge.
How long has he been in jail?
Your Honor, he's been in custody, just 1 second, Judge. Since December the 28th of 2023, Judge. So he's been in 20 days, Judge. And in all candor to the court, he does have a hold from Roswell, the city of Roswell. It's it appears to be a shoplifting charge. I don't know if it's an ordinance. So that would be my request, Judge, is to consider revoking him for 30 days and just closing out the case. Obviously, it's the court's decision.
I'm going to allow him to continue on probation. I understand the situation, but I'd like him to get the recommended evaluation if possible. All right.
All right.
So we will go with the recommendation as given to me by probation. All right. Anything additional?
No, Judge. Thank you. So.
All right. Thank you. Best of luck to you, sir. Are we finished with the probation calendar?
No, Your Honor. We're going to go to position number 9 and position number 10, Mr. Watkins.
Okay. All right, Mr. Watkins, your case is 17 CR 0028361B. You had a defective headlights and a failure to yield underlying charge. Please raise your right hand. Do you swear and affirm the testimony you give today be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right. And do you understand your rights today?
Yes, ma'am.
All right. Officer Brooks, your recommendation?
Time served, Your Honor.
I'm inclined to give that as well. Any objection to that, Mr. Haddad?
No, Judge. Thank you.
All right. Especially in light of those charges, time served will close out your case. Best of luck to you, Mr. Watkins.
Thank
and
you.
now that concludes the probation calendar, correct?
That's correct, Your Honor.
All right. Officer Brooks, does that conclude your business before the court?
Your Honor, I apologize. There was an add-on that I received.
Chambers.
There's an add-on probation? Oh, okay.
I apologize. I think Mike.
I'm sorry, what was that name?
Jonathan Chambers.
Okay, I didn't get that either. Let's see.
I don't have that either.
So I got an email, Mr. McLean and I got an email late Friday, and honestly, I forgot about it until just this morning when I heard another add-on calendar. But this is, Officer Allison had sent it.
Yeah.
And I can forward it to.
Can we please have it? Because I don't have it. Ms. Brooks, were you aware of this case, such as you have a recommendation?
Give me just 1 second to look at it right quick. I'll get one for you.
That's fine.
Okay, thank you.
And if we could send us that calendar.
And Your Honor, I did not get a calendar. I just got the petition, and the recommendation from Officer Allison is on there. I'd be happy to forward it to Officer Brooks or the court or whoever I need
Or
to.
just give us do you have the case number?
I do, Judge.
Does he have a probation violation number?
Just 1 second, Judge. I have the underlying case number, but I can find out the
It was hard to find the case because they changed it from an A to an E. I kept looking it up and find it.
And I have my recommendation, Your Honor, when you're ready.
All right. I think we have to find the probation violation number first so that we can.
Okay.
Do you have it, Officer Brooks?
I don't, Your Honor.
Your Honor, the booking sheet has it. It's a different style than what I'm used to.
Yeah, that's not the number, Mr. Haddad. That number has to be given. I don't know if we're going to be able to hear this case today. Because the clerk's office doesn't even have anything on this defendant.
Well, I'm not sure how Officer Allison.
I'm sorry, Your Honor. May we revisit him in a few, and I'll see, can I get that number?
Yes, let's come back to the probation calendar add-on. I'd like to take him today if we can. So if we can find the information to give Ms. Strong, I appreciate it.
Thank you.
Okay. Thank you, Your Honor.
Let me mention on that Chambers matter, I had initially some difficulty in getting the computer on it because it's based on case number 19 CR 005514A. But it turns out when I kept putting that number in, it said no match found. So I just started going through the alphabet, and if you put in 19 CR 005514E, then it pops up.
Okay. Maybe you email us what we have and we'll try to come back to this. All right.
ACDC is ready with our last one, Your Honor.
I'm ready. Who do we have?
Position 34 and 35, Angela White.
All right, Miss White. Where's my page 34? Your case, Miss White, is 21 CR 000099E. In that case, you're charged with simple battery and interference with custody. Do you understand your rights today, Miss White?
Give us a second to unmute.
Your Honor, I had indicated to the state and the clerk's office that we're going to waive arraignment and our plea of not guilty on this case, Judge.
Okay, so basically, Miss White, what's happened is your attorney is entering a not guilty plea via form for you, which means that they're going to set your case and continue. They're going to set your case for trial, but that doesn't necessarily mean you'll go to trial. It just means that your attorney and you will continue to work on this case to prepare. Okay? So your attorney will speak with, you want to, go ahead. Did you understand that, Miss White?
I didn't hear what the last thing you said was.
Oh, I'm saying is what's going to happen is your attorney is putting your case on the trial calendar. You and your attorney will work together as time goes forward to prepare for trial. That doesn't necessarily mean that you will go to trial, but it means that your case will not be resolved today and your attorney has some more work to do to prepare your defense. Okay?
Okay, I would like to plead not guilty. Thank
Yes, your attorney's entered that for you. All right?
Yes, ma'am. Thank you.
So your case will be reset to a trial calendar. Best of luck to you, Ms. White.
I have positions number 27 through 30. Ms. Terry, I'm sorry.
27 through 30. All right, and the announcement for Mr. Terry's case?
That would be a negotiated plea, Judge.
Okay, Mr. Terry, you are here for 2 FTAs, and then your underlying case is 23 CR 003977A, in which you're charged with criminal trespass. Do you understand your rights?
I understand.
All right, please raise your right hand. Do you swear and affirm the testimony you give today for the very limited purposes of taking a plea will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right. Can I have the brief factual basis and offer from the state?
Your Honor, the brief factual basis on case ending in 977A, where the charge is criminal trespass, is that the defendant was found inside the Midtown Urology Doctors building located at 1924 Piedmont Road. One moment. Piedmont Road, the suspect was sleeping inside the doctor's office and locked the door from the inside. The defendant also wrote on several walls inside the office with red ink. Your Honor, the recommendation from the state as it relates to that case, one moment, is as a part of this global recommendation, the defendant is to serve 12 months probation, to serve 48 days in custody, credit for the 24 days that the defendant has already served in custody. Balance probated, that is to go non-reporting. They are to, one moment, they are to stay away from the 1200 Abernathy Road, North Park Town Center. That is for the other case. And as it relates to this case, they are to stay away from the 1924 Piedmont Road, which is that Midtown Urology, and to have no alcohol, drugs, or weapons. The factual basis of the remaining case, Your Honor, that case ending in 780A, charged with criminal trespass, is that on 7/22/2020, the officer was dispatched to a loitering call at that 1200 Abernathy Road location. Upon arrival, they met with the security officer who stated that the defendant was sleeping inside the elevator lobby on the top floor of that building. Once the elevator doors opened, the officer noticed a sleeping bag that was laid out on the floor with a backpack and 2 other bags next to it. There was also a sweatshirt that was tied around the door handles of the 2 doors that led to the parking garage. The defendant was standing near the sleeping bag and stated that a female told the defendant that they had to leave the property that day before, but advised that they could come back later. The defendant gathered their belongings and got on the elevator with the officer to go downstairs. The officer was advised that the defendant had been issued a criminal trespass warning on what appeared to be 1 day prior, which is 7/21/2020. The recommendation in that case, Your Honor, as a result of this global plea, is a time serve offer to serve 21 days, credit for the 21 days that the defendant has already served. Looks like they were booked in on December 27, 2023. Nothing further to add from the state at this time, but if we could get the defense to stipulate to venue and factual basis an ID, that'd be greatly appreciated, Your Honor.
All right. Do you so stipulate?
We stipulate, Judge.
Mr. Haddad, thank you. All right. I'm going to ask you some questions, Ms. Terry. Reminding you are under oath, all right? All right. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take this plea today?
No.
Did anyone promise you anything in exchange for taking the plea?
No.
And are you satisfied with your attorney's representation?
Yes.
And you understand that taking a guilty plea may affect other aspects of your life, such as any open cases, probation, or other aspects of the case I may not be able to anticipate?
Yeah. Yes.
You understand you're giving up your right to trial by judge or jury?
Yes.
And you understand you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
All right. As to the charges previously listed in both of your cases, how do you plead?
Guilty.
Oh, and you further understand the requirements that you cannot go back to either of those locations. You understand that?
Yes, I understand.
All right. I accept your guilty plea. Is there anything additional from the state or the defense?
The state would just like to notate that as a result of this guilty plea, negotiated guilty plea, the state will be null processing the remaining 2 failure to appears on the calendar.
All right. We appreciate that. Thank you. All right. Anything additional, Mr. Haddad?
No, Judge, thank you.
All right. Best of luck to you. All right, who do we have next?
Your Honor, next we're gonna go to position number 5, 6, and 7, Michael Carter.
All right, Mr. Carter, your cases are 20 CR 00610-4J, you're charged with battery family violence. 23 CR 003807J, you're charged with simple battery family violence. And 24 CR 000006J, and which you're also charged with simple battery family violence. You understand your rights?
Ma'am.
All right, and if this is a negotiated plea?
It is.
All right, Mr. Pierre Thomas?
One moment, Your Honor. Your Honor, as it relates to the case ending in 6104J, the brief factual basis, that charge being battery family violence versus defense, the brief factual basis is that on December 18, 2020, the law enforcement responded to a dispute at the incident location, that being 4046 Esther Drive, Southwest Atlanta in Fulton County, Georgia. Upon arrival, the officer spoke with the victim, Charlotte McCullum, who informed the officer that her boyfriend, the defendant, Michael Carter, kicked her in the side of her body, causing pain and bruising. Your Honor, I believe the recommendation from the state as it relates to that charge is for the defendant to serve 365 days, credit for, one moment.
Oh, I see that. I know why you said that. To serve, should it be the credit for the 3-day, credit for serve 6 days, credit for 3 for that position?
That's what it appears to be. One moment, let me double check, Your Honor.
Okay.
Your Honor, that was an error on the state's part. That was supposed to be 365 days credit for time served 3 days.
Okay.
So that was an error on my part, and I do apologize.
All right, Your Honor. So it is to serve 365 days on the case ending in 6104J. It is to serve 365 days credit for, it looks like 4 days on that one. This is as a result of a global recommendation. As it relates to the next case ending in 3807J, that case being, that charge being simple battery family violence. Brief factual basis is that on January 8, 2022, the law enforcement officer responded to a call that was placed by Miss Charlotte McCullum, the victim in this case, who reported that she was assaulted by her live-in boyfriend, the defendant. Ms. McCullum, the victim, advised that she was watching TV and with the defendant when she attempted to go to bed. The defendant became irate and followed her into the bedroom, where he yelled and harassed her, and she told the defendant to shut up, at which point he punched her in the side of the lower back area. The officer noted that she was obviously in pain when the officer arrived. The recommendation from the state as it relates to that case ending in 3807J is for the defendant to serve 365 days credit for the 3 days that he's already served. Looks like the custody would have begun on 6/15/2022, and they would have been released on 6/17/2022. That is to be concurrent with the case ending in 3807J. And lastly, Your Honor, for the case ending in 006J, looks like the charge is simple battery family violence. Brief factual basis is that on October 4th, 2023, the law enforcement responded to a dispute call at the incident location, that location being that 4046 Esther Drive, Southwest Atlanta, Georgia location in Fulton County, Georgia. When the officer arrived, they spoke with the victim, same victim in the other 2 cases, Charlotte McCullum, who informed the officer that while in bed, she was accidentally kicked by the defendant's foot, and that his foot was injured the previous day, and that he was still in pain. Ms. McCullum then stated that the defendant then kicked her to the left side of her stomach, causing pain, and she was ultimately transported to the hospital for medical attention. The recommendation from the state as it relates to the case ending in 006J is for the defendant to serve, there to be 12 months probation, that is to be consecutive, to the other two cases, the case ending in 807J, for the balance to be probated for the defendant to complete a family violence intervention program, to complete 40 hours of community service, to have no firearms, to have no contact with Charlotte McCullum, to stay away from that location of 4046 Esther Drive, Atlanta, Georgia. And if at this time we can sound for Ms. McCullum in accordance with Marcy's law, that'd be greatly appreciated, Your Honor.
All right, and that is his final case, correct? Is Ms. McCullum on this Zoom conference and wishes to make a statement? I don't see or hear anyone with that name. All right, Ms. McLean, was that your understanding?
So if I understand correctly, case number 5 is time served essentially, right? And then case number 6 is also that. And case number 7 would be 12 months probation consecutive.
That's not my understanding. It's 360
No,
days.
it looks
to
like
serve.
they want him to serve more time.
Oh, you're saying that number 5 and number 6 are extra time cases?
Yeah, a lot. It appears to
Yes.
me to be a lot of extra time. Say he's only getting credit for 8 days in one and 6 days in the other, with the requirement that he served 365 days. So that was not your understanding, Mr. McLean?
Right, I was just looking at the, we always put down 3 numbers, 365-8-4 and do the math. But if number 5 and number 6 are not time served cases, then I need to consult with Mr. Carter.
All right.
Right,
Please.
and Your Honor, I understand that this turns this case into a non-negotiated plea. Again, that was the state's error. Our intention was 365 days to serve, which is why we put 365 as opposed to our normal 12 months.
Okay.
Ready and you don't
All right. Do you wish to speak with Mr. Carter briefly, Mr.
Yes,
McLean?
yes, Your Honor. Yes, Your Honor. We'll revisit that, and I may be announcing that we won't be doing this plea today.
Okay.
Not worried about it.
Your
All
Honor,
right.
position number 9, Mr. Rodney Davis, position number 9.
All right. Good afternoon. I'm sorry. Good morning, Mr. Davis. Your case is 23 CR 004378D. You're charged with DUI and reckless driving. Do you understand your rights?
Yes, ma'am.
All right. And the announcement, Mr. McLean?
That's a negotiated plea, Your Honor.
All right. Ms. Falk, is this your case? You're muted.
Just realize that. Yes, Your Honor, it is. And I can briefly go over the facts and the recommendation. And so this incident happened November 26, 2020. Officers responded to 274 East Paces Ferry Road Northeast in reference to an intoxicated driver. The officer observed a black GMC Terrain against the curb on the opposite side of traffic with 2 flat front tires. They made contact with the defendant, who and smelled the odor of alcoholic beverage. He was asked if he had consumed any alcohol. He first stated 2 Budweisers. He then changed his answer to 3 Budweisers. Officers noticed he had slurred speech, was unable to maintain his balance, and appeared to have urinated on himself. He was then placed under arrest for DUI less safe. State's recommendation on this case is to count 1 is 12 months served 24 days, credit for time served 12 days. That's from January 5th, 2024 to today. Balance probated, ADET, DUI risk reduction, a $1,000 fine, 120 hours of community service, victim impact panel, and an interlock device. Count 2 would merge with count 1 for the purposes of this plea, and we would ask the defense to stipulate as to venue, factual basis, and identification.
We do so stipulate.
And that was your understanding as well of the offer?
Yes, Your Honor. We have fully discussed this, including I warned Mr. Davis that when it comes to a DUI fine, that $1,000, there are various surcharges that could take that up to $1,800 or $1,900. So he's aware of that as well.
Okay, thank you, Mr. Davis. I'm gonna place you under oath. Please raise your right hand. Do you swear and affirm testimony you give today be the truth to the best of your knowledge under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
I would like to add something.
You would like to add something?
Yes, ma'am.
Okay.
I wouldn't have never got that,
No. I don't want you to say anything that might affect this plea. Do you
I didn't never get the mail.
want to speak to Mr. McLean quickly about something?
He just wants to talk about his mail delivery, Your Honor. It'll be brief.
Okay, go ahead.
Not particularly relevant to anything, but it'll be very brief.
The court sent, the mail for me to report to court to the wrong address. I didn't never receive it. They sent it to
Okay.
a 20 year, that I used to stay at the address 20 years ago.
Do you still want to take the plea today, or do you want to go to trial?
No, I wouldn't take the plea. I just wanted to let you guys know that I ain't never received the court date.
Okay. And you understand that taking a guilty plea, you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you further understand that taking a guilty plea may affect other aspects of your life that either your attorney or I may not be able to anticipate. It may affect employment, probation, or other things of that nature. You understand that?
Ma'am.
And you understand you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Yes, ma'am.
And you further understand the requirements, including the course you have to take, the fine, the evaluation, and the community service, as well as the interlock device that's going to be placed. Do you understand all of that?
Yes, ma'am.
All right. And you did, and just to confirm, no one promised you anything, you are voluntarily taking a plea today.
Yes, ma'am.
All right. As to the charge of DUI, how do you plead, Mr. Davis?
Guilty.
I accept your guilty plea. Is there anything additional?
Nothing.
All right, and make sure he fills out that probation form with his information as well. Officer Brooks, were you able to find anything regarding the add-on case so that we could hear it today?
Yes, Your Honor.
All right. What did you find? Did you find a booking, a number that would allow the clerk's office to process?
Yes, Your Honor.
What did you?
23-002-382 PB.
Is that sufficient, Ms. Strong? Can we hear that case?
No, ma'am.
We cannot. There's nothing we can do?
No, the person that issues these PV numbers is out of the office until tomorrow. We don't do these. So the soonest I could do it would be Thursday if we do an add-on. But that's not the PV number that we use.
Okay. All right.
Your Honor, may I mention, I think they're looking for the 23 PV-00 something.
Right, and what Ms. Strong is saying is that still is not sufficient information to process it within the clerk's office today.
I think the record room can handle it, okay? Your Honor, I would present the same facts to argue for today's release from jail on a signature bond as I would for the revocation itself. He went to rehab, he went to a halfway house. He's done quite a bit, and we have a very strong argument.
So, okay, I understand that. I'm just trying to make sure that what if we don't have the paperwork right, he won't get out anyway. So that's what I'm trying to figure out. So you're asking.
Correct. So, Mr. McLean, can we please reset him to Thursday so that we can have all the information that we need in the clerk's office and on the other end to be able to take care of this case?
If there's any way to go forward today, we'd really.
They don't want him to sit in jail, which
Right.
Can I go on a Ms. Strong, can I go on a breakout with you really quick?
Okay.
I understand the situation. Hold one moment for me, please, everyone. Okay, we're gonna keep working on that case for a moment. Ms. Brooks, please bear with us. Please don't leave us yet. All right,
Yes, Your Honor.
is there another case we can take?
Your Honor, whenever you're ready, we got position number 10 and position number 11, Mr. Matthew Flowers.
All right, Mr. Flowers, I'm ready. Is Mr. Haddad and Mr. McLean there?
Yes, ma'am.
Yes, Your Honor.
Okay.
That's ready.
All right, Mr. Flowers, we're gonna take up case 23 CR 001471E. You're charged with criminal trespass and damage to property, as well as an FTA. Do you understand your rights today?
Yes, ma'am.
All right. And the announcement I have is negotiated plea. Is that still correct?
Yes, it's negotiated plea, Your Honor.
All right. Thank you, Ms. Falk.
Yes, Your Honor. This incident happened March 13th, 2023 at 651 Moreland Avenue Southeast. It's the property of DJ Mortgage. Officers spoke with Mr. Garcia, who was hired to do construction for that company, and he observed a broken front doorknob to the house, and the defendant inside, who refused to leave when asked. The officer then asked the defendant to leave. He refused, and then the officer was able to gain entrance into the building and take the defendant into custody, and as well as the front doorknob, the back doorknob, upstairs bedroom doorknob, and the outer side of the front door were damaged. The state's recommendation in this case is 12 months served, 42 days, credit for time served 21. That's from March 13th to March 14th of 2023, and then December 29th of 2023 to today. Balance suspended, stay away from 651 Moreland Avenue Southeast in Atlanta. We did attempt to reach out to DJ Mortgage to get restitution information, and we're unable to do so. And that's been since March. That's all for the state.
All right. Mr. McLean, do you stipulate to factual basis, ID, and venue? And was that your understanding of the offer?
For the purposes of today's plea, we do so stipulate, and it is our understanding, yes, Your Honor.
All right, and there was no additional time served under this plea, correct?
That is correct, Your Honor.
All right, Mr. Flowers, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury? All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time? Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand that taking a plea may affect other aspects of your life, such as employment, immigration, or other things I can't anticipate?
Yes, ma'am.
And you understand you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you further understand that you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand that you cannot go back to that location, but otherwise the time you served in Fulton County Jail will close your case?
Yes, ma'am.
All right, as to the charge of criminal trespass and damage to property, how do you plead, Mr. Flowers?
Guilty.
I'm sorry, you plead what?
Guilty.
Okay, I understand, and I accept your guilty plea. Is there anything additional? All right, best of luck to you. That concludes your case.
Thank you, Your Honor.
All right.
That's it. Thank you.
Next, Your Honor, we're gonna go to position number 12, Mr. Hewitt, Edward Hewitt, position 12.
Okay. All right, Mr. Hewitt, your case is 23 CR 005157G. In this case, you're charged with criminal trespass. You understand your rights?
Yes. Your Honor, this one is similar to a couple others where there is another case with, I'm not saying similar certainly, but there's a felony case in which we do have to consult with the felony lawyer as soon as one is appointed, if one has not been appointed yet, because one case could affect the other.
So we're asking for a 1 or 2 week reset.
I think it needs to be 2 because
All right.
he does not believe he's been appointed that lawyer yet, and we're going to have to ask somebody to appoint one really quickly.
All right, we will reset SAP 130 for position 12, okay?
Thank you, Your Honor.
All right, you understand that, Mr. Hewitt? We are not addressing your case today. But your attorney has some additional inquiries to make, so your case will come back up in 2 weeks.
Okay.
All right, take care. You have I'm sorry, what were you gonna say?
For me, Mr. Hewitt, you're gonna ask me a question. Your Honor, he plans on making that $5,000 bond, this week.
All right, thank you. Understood. We can go to the next page.
1 week. Thank you. No problem.
Next, Your Honor, you're gonna go to position 25 and 26, Mr. Jordan Quinn.
All right, give me one moment. I need to check one thing. Thank you.
Gonna be okay? Mr. Pierre Thomas, is that gonna be okay? Position number?
Yes.
Okay, I apologize. I just met with him this morning. It's for a plea, negotiated plea as outlined by the state.
Okay.
All right, my apologies. We're gonna take up case 23 CR 001172Y, in which Mr. Quinn is charged with criminal trespass and 2 counts of battery. What is the announcement? I'm sorry, Mr. Quinn, do you understand your rights today?
Yes, ma'am, I do.
And the announcement?
There'll be a negotiated plea, Judge.
Okay, thank you. Mr. Pierre Thomas, if you would present the brief factual basis.
On a brief factual basis, in the case ending in 1172Y, where the defendant is charged with criminal trespass and 2 counts of battery, the factual basis is that on July 31st, looks like 2022, the officer responded to the incident location, which is 1507 Summit Place Drive in Fulton County, Georgia. Upon arrival, the officer met with the caller, looks like Shireen Metcalf, better yet. She stated that she had a friend, the defendant, who was at her house, and they were hanging out celebrating her birthday when the defendant got drunk and started to act in a violent manner towards her and her friends. Ms. Metcalf stated that the defendant punched one of her friends, one of the victims in this case, Ms. Michelle Dixon, in her mouth with a closed fist. The victim, Dixon, had a severe bump to her upper lip and a major cut on her bottom lip. The defendant proceeded with his violent behavior, punching a juvenile who we will refer to by the initials as I and F, in her forehead, causing a bump. The defendant fled the scene before officers could arrive. The recommendation from the state in this case, Your Honor, is on count 1, criminal trespass, for the defendant to serve 120 days in custody, credit for the 25 days that they've already served in custody. On count 2, 12 months probation to serve 120 days in custody, credit for the 25 days that they've already served in custody, for the balance to be probated, and for them to complete an ADET, to have no contact with Michelle Dixon, the victim in this case, to stay away from 1507 Summit Place Drive, and to have no alcohol, drugs, or weapons. And on count 3, 12 months probation to be concurrent with count 2, to serve 120 days in custody, credit for the 25 days that they've already served, which appears to be from February 28, 2023 to March 4th, 2023, and again booked in on December 18, 2023, for the balance to be probated, for there to be 8 weeks of anger awareness, to have no contact with the juvenile victim in the case, initials again, I and F, to stay away from the 1507 Summit Place Drive location and to have no alcohol, drugs, or weapons. As a totality, Your Honor, that it will be 12 months probation to serve 120 days in custody, credit for the 25 days already served, balance probated, to complete 8 weeks of anger awareness, and to complete a ADET, and to have no alcohol, drugs, or weapons, no alcohol, drugs, or weapons, and then also to stay away from the 1507 Summit Place Drive location. Our office has been able to get in contact with the victim. I don't believe that the adult victim will be on the call. However, they were notified and agreed to the plea that was offered by the state here today. If we could still sound for them in accordance with Marcy's Law and in an abundance of caution or precaution, that'd be greatly appreciated, Your Honor. And if we could get the defendant to stipulate to factual basis, venue, and ID, that'd be greatly appreciated as well. Nothing further to add from the state at this time.
All right, thank you. I'm sounding for Ms. Dixon at this time. All right, hearing none, I am further sounding. Oh, I won't sound for the minor. All right, do you so stipulate to the elements? Mr.
Judge,
Haddad?
we do stipulate, I did want to be heard as far as the jail portion.
Okay, so it's a non-negotiated plea.
No,
Mr. I'm sorry.
It is a negotiated plea. The request that I have is that I'm gonna respectfully request the court to give them additional time for credit, and I can explain that. And I understand if the court is unwilling, but I can explain briefly, Judge, as far as that he's owed a little bit more than the 25 days. And I only discovered this morning, Judge.
Okay, tell me about it, but was he actually booked in on those charges? Because even if I agree, if the jail on there, this happened a couple weeks ago, if the jail does not show that he was booked in, he won't get that credit. So do you have any way of, let me hear what you have to say. Let's see what we can do.
Sure, Judge. So, my client, Mr. Quinn, was arrested on October the 23rd of 2023 in Forsyth County for a felony probation violation. A hold was placed from Fulton County for this case. So I'm just simply requesting the court to grant him credit from the 23rd of October when a hold was placed. I understand that the court does not have to. I recognize that, Judge. I mean, the court can choose not to. Either way, Judge, I was going to ask the court to do that. If not, I explained to my client that if the court is not inclined, they will still have additional time, technically on the Fulton County case, Judge.
I'm bad at math, Mr. Haddad. How many additional days would that give him?
So, so from the 23rd, I mean, 7 days in October, 30 in November, and 31 in December. He was finally brought to the Fulton County Jail on December the 28th. So in essence, it will be a time served sentence. Now, I did want to let the court know he is still serving a probation violation from Forsyth. So he's not going to be released for another 30 days or so from Forsyth County anyway.
And just for the record, Your Honor, I'd like to put on the record that the state would object to that.
I understand.
I'm sure the state would object. I'm not even sure it's possible because even though the hold is technically placed, Mr. Haddad, I think that he still has to technically be in that Fulton County Jail and booked in on that charge. So I don't think I could, even if I want to do that, I don't think I can.
Understood.
So unfortunately, I cannot accept that additional time. Does your client still want to take the plea?
Yes, Judge, we're ready for a plea.
Okay. All right. Sir, please raise your right hand. Do you swear and affirm the testimony you give today for the limited purposes of taking the plea will be the truth to the best of your knowledge and under the penalty of perjury?
I do.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
You understand you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you fully understand that by taking a guilty plea, it could affect other aspects of your life that I may not be able to anticipate, such as employment or immigration?
Yes, ma'am.
And you further understand the requirements that you have to complete upon your release, that you have courses to take. You cannot have any contact with the alleged victims in this case, and that you cannot return to that address on Summit Place?
Yes, ma'am.
All right. As to the charges I previously listed, Mr. Quinn, how do you plead?
Guilty.
I accept your guilty plea at this time. If there's nothing additional from the state of defense, that will conclude your case.
Thank you, Judge.
And Your Honor,
All
as a result of this negotiated guilty plea, the state will be null processing the remaining failure to appear on the calendar.
All right, thank you.
Thank
Please
you.
send null process paperwork if you can. Start sending it now. We would appreciate it. All right. Who do we have next?
Next, Your Honor, we're gonna go to Mr. John Wright, and that is, position number 36.
Okay. All right, Mr. Wright, your case is 17 CR 0067958H. I'm not gonna sound that charge. Do you understand your rights?
Yes.
All right, what is the announcement for this case?
That is a negotiated plea, Judge.
All right, Mr. Thomas, please don't give me the factual basis. I just would like to hear the offer.
Yes, Your Honor, of course. The offer from the state as it relates to that charge is a 12 months probation to serve 100 days in custody, credit for the 26 days that he's already served in custody, for the balance to be probated, for him to submit to SDET, to stay away from the Erman Perry Park located at 1721, looks like Wilma, WILLMA Drive, to complete 40 hours of community service and to have no alcohol, drugs, or weapons.
All right, and do you stipulate to those the three elements, Mr. Haddad, and was that your understanding?
It is, Judge. We do stipulate to the facts as well. I would just ask the court to follow the state's recommendation. Mr. Wright reported to me that he turned himself in an effort to resolve this case. So I wish to, we respectfully request the court to follow the state's recommendation.
All right, Mr. Wright, I'm gonna ask you some questions, okay? Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time?
No.
Are you satisfied with your attorney's representation?
Yes.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking the plea?
No.
And you understand that taking the plea can affect other aspects of your life, such as employment or immigration or other things that I may not be able to anticipate?
Yes.
And you further understand that taking a guilty plea, I'm sorry, and you further understand you'll have no other court dates about this, you're giving up your right to trial?
Yes.
And you understand the requirements and what you'll have to do, including some evaluations, community service, and things of that nature?
Yes.
And you further understand you can't go back to that park?
Right.
Is that a yes?
Yes.
All right, as to the charge that I did not sound, but I'm sure you're aware of, Mr. Wright, how do you plead?
Yes.
I accept your guilty plea at this time. Is there anything additional?
No, Judge.
All
right.
State, Your Honor.
All right, best of luck to you, sir. That's gonna conclude your case, okay? All right, who do we have next?
That's all I have in courtroom, too, Your Honor. I just have Mr. Chambers. Still waiting for Mr. Chambers.
Okay, Mr. Chambers's case is the one that we're trying to still figure out. Mr. McLean had a suggestion earlier. The problem is there's no way to process that case. I want to get him out. I do. Mr. McLean, what was your earlier suggestion?
Your Honor, I could put on the same exact information that I would in a revocation and simply make a bond argument for a signature bond. and have him come back and hit the revocation later.
So okay, let me just make sure I understand. We would give him an SOB and then he would report to probation. And then
Right.
how would he get back on it? How would he get back on this calendar to make sure that the probation order actually gets entered and signed? Because the problem is the clerk's office can't process. I'm thinking. Okay, so if we give him the signature bond, how does the probation case, the probation violation get addressed? Because they're not gonna let him out of the jail, Mr. McLean, unless there's something to enter to deal with that.
Right. Sometimes what we do is we have on one in the style of the case on the upper right-hand side, we put all the numbers. We say the case number with the CR, then we mention the PV in front, the PV in back, and we say these are all the associated numbers. And so they know the same thing.
Ms. Brooks, what was your recommendation anyway? What did you have a recommendation for this case?
Yes, Your Honor, I'm recommending revoke.
Oh, she's recommending revoke anyway.
Right. His dad was talking on the phone last week with someone else in the office, and they had a different notion. So
okay,
I'm not
because the recommendation is revoked. We're gonna add him on to Thursday anyway. Okay. All right. So unfortunately, Mr. Chambers, we can't really process this anyway. We're gonna put him as an add-on to Thursday's SAP. Ms. Strong, please tell Michael about this situation so that we can.
I'll take care of it right now.
Okay, because we can't really address it anyway. Okay. So unfortunately, we will have to reset that case. Is that the entire calendar?
Yes, Your Honor, that's all I have.
Do we have a DV reset today? Ms. Strong? I thought I saw that. What happened to position?
It was Lamarcus Ames.
Okay, so we still have an 11 o'clock.
I do have one remaining idea on that, Your Honor. We're only about 500 feet from the hallway door of the record room. Why don't we ask them if they can grab that number and process it?
Because there's still a PB number that the clerk's office has that no one knows how to quite deal with. So it's still not gonna work, even if we had that number. Is that correct, Ms. Strong?
Correct.
Right. So there's an internal challenge that I understand that you are concerned about that we can't really deal with at this time. Okay. So we have to reset him to Thursday, but he will be an add-on. But again, Ms. Brooks is recommending a revocation anyway. So
and I apologize. What is his case number?
The case number is 19CR005514, and the petition we were sent by email attachment said the letter A, but when I looked it up in the computer, that said no match. So I just started going through the different judges' designations, and when I called it 19CR005514E, then it came up on the computer.
Okay. Also, on the add-on calendar
It didn't look like I was a computer hacker, did it?
on the add-on calendar that was sent out, Sanchez Griffin, was that case being handled today?
will that person be brought today?
Haddad. Yeah. I actually took him back. Mr. Haddad said that you guys didn't need him. Yeah.
Where are we resetting that case?
Yeah, Judge, the Odyssey shows that it's going back on the 22nd in front of a judge, and that's what what Mr. Griffin told me, and he wanted to keep it for the 22nd. So I just don't know anything about the case other than what he told me, and I confirmed on Odyssey, it does show the 22nd, and he was fine with it. So I'm just leaving it at that.
I'm sorry, he was going back where on the 22nd?
To his original courtroom, Your Honor. That was a
okay.
case where one case was already in front of the judge. He had a second case that was then put on our calendar, and he declined to take any kind of plea offer. So we reset both cases to Judge Richardson's courtroom.
That's fine. That's more than fine. So that's that resolution. Okay. All right, so we're holding on the 11 o'clock DV reset, but otherwise, have we completed the entire calendar?
Your Honor, I think we have to go back to Mr. Michael Carter, 567.
Oh, that's true.
67.
Yeah, that's true. What was the announcement for that case?
I think we have to reset that case, Your Honor, for further consultation on that. He might or might not be able to make the bond. He's not sure.
Okay, so he's not taking the plea because of the time served. You're asking that he be reset for trial, or are you asking for another SAP reset date?
If we can have another SAP reset date, we'll have a chance to discuss it further with the state.
Who is this?
Mr. Carter, 5, 6, and 7.
And
So
how long
we
is it resetting?
we're gonna reset it 2 weeks. We're gonna put it on the 30th.
Okay.
I'll talk to the state in the meantime. We'll talk about that more.
Okay. I'm just looking to see. Ms. Ron, do you see that we're missing any other positions?
One moment, maybe I missed it, but hold on a second.
I'm looking as well. What about 19 and 20?
19, that's the one I was,
What do we have an announcement for 19 and 20?
The state requested a reset on that. There are 2 additional open cases, so we asked to be reset to January 23rd to address all of his cases as a global recommendation.
Okay, that sounds fair and efficient. We'll do that.
Ms. Falk I'm looking while I'm asking, but were his other case numbers on the?
Yes, they are, but I can give them to you now. It is 22 CR 006163Y and 24 CR 000048Y. And can you let me know if they can be reset to the 23rd, or do we need to push it out to the 30th?
Can we do the 30th, please? Because we're filling up the 23rd as we speak.
Totally understand.
Okay. Were y'all waiting on me?
Yes, I want to know if there was other positions you saw.
23, did I miss that one? Peyton?
We didn't do 23. Was there an announcement? The announcement on Peyton, I believe, was to reset that, Your Honor.
23rd?
23rd, that'd be 1 week. 1 week.
Can we reset it 2 weeks? Ms. Strong just said we're full on the 23rd.
Yes, Your Honor.
Okay.
It won't affect them. I know.
All right. I think that was all.
Is Ms. Strong, is somebody gonna go over the entire calendar? Just so
We are gonna review. I'm just making sure that there's no other positions that have.
Last one is 33. Did I miss 33?
Let's see.
He bonded
Okay.
out. He
was released?
Yes.
33 was released. Okay. Okay, we're gonna review the entire state all-purpose and probation calendar.
Position number 1 and 2 are reset for next Tuesday's SAP calendar, January the 23rd. Position number 3, reset for next Tuesday's SAP calendar, January the 23rd. Position number 4 is reset for January the 30th, SAP calendar. Position number 5 is reset. 5, 6, and 7 are all reset for SAP January the 30th. Position number 8, reset SAP January the 30th. Position number 9 was a negotiated plea. 10 was a negotiated plea. Position number 11 was null pros. Position number 12 is reset for January the 30th SAP calendar. Position number 13, 14, 15, 16, 17, 18 are all reset for February the 15th competency calendar. Position number 19 is reset for January the 30th SAP calendar. 20, January the 30th SAP calendar. Position number 21 is reset for 21 and 22 are reset for next Tuesday, January the 23rd SAP calendar. Position number 23 is reset for January 30th SAP calendar. Position number 24 was a negotiated plea. Position number 25 was a negotiated plea. Position number 26 was null pros. 27 was null pros. Position 28 was null pros. Position number 29 was a negotiated plea. 30 was a negotiated plea. 31, negotiated plea. Position number 32 was null pros. Position number 33 was release. Position number 34 was waived arraignment, not guilty, reset jail jury. Position number 35 will be reset to follow that case. And position number 36 was a negotiated plea. On the add-on calendar, position number 1, Xavion Kelly is reset for next Tuesday's SAP calendar. And position number 2 was returned to the division judge. And on the probation revocation calendar, position number 1, the probation was revoked. 2, the case was dismissed. Position number 3, probation was revoked. 4, dismissed. Position number 5 was to continue on probation. Position number 6 was the dismissed. Position number 7, probation was a probation violation. Position number 8 was dismissed. 9 was dismissed. 10 was time served. 11 dismissed, and 12 was a probation violation. Any questions, concerns?
Your Honor, if a miracle occurs and I'm successful at the record room in finding the correct number, am I looking for the number on Chambers that's in the format of 2 digits for the year, the letters PV, a dash or hyphen, and then a couple of zeros and then some more numbers? Is that the one I'm looking for?
No, we would need the actual number of the probation violation. Is that correct, Ms. Strong?
Correct.
Which format would that be? Would that be the one that has the PV at the end of the case number?
No, the way that's written on the calendar, which is the 24 PV or 20, whatever, 24 PV and the numbers to go behind it. Which is something that we do in the clerk's office, Mr. McLean.
Okay, all right. Well, I will consult with the record room if there's any chance that maybe we can do this at 2 o'clock, but I realize that's a minority chance of occurring, but I'll give it a shot.
All right, I'm gonna look at the DV calendar. Let me see. It is now 11 o'clock, so that party should be on the line. Let's see.
I didn't see a DV calendar.
Excuse me, Your Honor. So you have him on the add-on calendar for this upcoming Thursday for Chambers?
I think so. Yes, Mr. McLean is gonna go try to do something very quickly while I start the 11 o'clock calendar.
Okay.
There was a DV. Did I make that up, Ms. Strong?
No, ma'am, there is LaMarcus Ames.
That is correct, Your Honor.
Okay. And is Mr. Ames on his Zoom conference?
Good morning, Your Honor. Javier Trejo on behalf of Mr. Ames. I've spoken to my client and I've advised him to be on this Zoom call. I will follow up with him to make sure that he is here.
Okay, why don't you give him a quick call because he's not here.
Yes, ma'am.
Thank you.
Yes, Your Honor. I spoke to my client over the weekend and this morning, and I'm now unable to reach him. I'm not sure if he has joined in the last few minutes, but I don't see him.
And Your Honor,
Okay.
just to kind of round out the record, this defendant failed to appear for jury trial on January 3rd, 2024, before Judge Morrison, which is what led to his bond being ordered forfeited.
One moment, Judge. I think I'm getting a call from my client. One moment. I'm sorry.
Okay. Okay.
Yes, Your Honor. My client has just joined the Zoom.
All right. Thank you, Ms. Falk. I'm sorry, you were going to give me the posture of this case.
Yes, Your Honor. This case with LaMarcus Ames, the defendant.
Oh, wait, hold one moment. He's connecting to the audio. Let's make sure he can hear. Okay, Mr. Ames, we were just discussing your case. You are on the DV bench warrant case. At this time, there is a bench warrant because of your failure to appear for court. Your case is 22 CR 007870E. All right, I'm sorry, Ms. Falk, please continue.
Yes, Your Honor. What I was saying is the defendant was scheduled for a jury trial on January 3rd, 2024. Led to this bond being ordered forfeited.
I think I lost you for one moment, Ms. Falk. Would you mind? I apologize. Would you mind repeating some of that?
He failed to appear for jury trial with Judge Morrison on January 3rd, which led to the bond being ordered forfeited and a rule nisi being issued. The amount of the bond that was set by Judge Morrison was $3,500.
Okay. And Mr. Trejo, does your client have any reasonable explanation? What did he not receive the notices? Do we have any proof of return of services, Ms. Strong? Give me one moment.
And Your Honor, while Ms. Strong looks for the proof of service, my client did appear for court that morning. He appeared, he was present during the initial call of the calendar. What happened here was, Your Honor, we broke for lunch at around noon that day, or noon or 12:30. We were ordered back in court at 1. The state and I continued negotiating and pre-trying the case through the lunch break. Once we returned from lunch, I spoke with my client and we confirmed what our announcement was going to be on that calendar. I let him know that that we would make that announcement after that point. It would be a short day. He would likely be excused after that point. I think there was a miscommunication. My client ended up leaving the courtroom, and then he was not present for the second call of the calendar, which prompted the failure to appear. The reason why we're on this calendar currently, Your Honor, is because this is my client's first failure to appear. He was present for arraignment. He has been present in meeting his obligations on his bond. And we believe that this is just a misunderstanding. And that is why we're now seeking the warrant to be lifted.
I'm unclear, Mr. Trejo. Again, he was there in the morning. You took a break for lunch, and then what happened again?
And then he came back after the lunch break. He and I spoke. We told him we would be making our announcement, after which point he would likely be dismissed. And then I think he thought he was already free to go, so he left. And then when the calendar was called the second time, he wasn't present, and then he was marked down as failing to appear.
Okay. All right. I'm sure the state objects to this, but I will lift the bench warrant one time based upon that representation that you made to me, Mr. Trejo, that he was there and spoke with you. In the meantime, is there a plea offer at this time, Ms. Falk?
No, Your Honor, there is not.
There's not. Okay. Well, we will reset him further notice for trial. Mr. Ames, you are getting a second chance. Typically, what would happen is you would have had to surrender yourself to the Fulton County Jail and bond yourself back out. We do not want to hear that this is happening again. I'm allowing you this one time reset and lift of the bench warrant. Okay? You're muted. You understand? All right. Keep your address current with the court and stay in touch with Mr. Trejo. Do not do this again. All right. I believe that concludes the entire calendar. Did Mr. McLean come back? And there's still nothing we can do, Ms. Strong, with Mr. Chambers' case?
No, ma'am. He's been reset to Thursday.
All right. I did all I could. I think I deserve the Snicker bar of the day for that effort. All right. We have concluded the entire SAP probation, revocation, and DV reset calendar. Please submit all null process and probation orders to Ms. Strong for my signature so that we can get the documents sent in. Thank you.
And all plea
Thank you,
paperwork
Judge.
to Ms. Strong, please.
All plea paperwork. Did I leave out plea paperwork?
I'm not sure. All paperwork. Thank you.
All paperwork. Please send.
I received those, Ms. Falk.
Really quick question, Ms. Strong. Do we have the calendar yet for the 18th? I may have missed it.
It came out on Friday.
Okay. So I did miss it. Thank you. I will go back through and find it. Thanks. I appreciate it.
No problem.
All right. Take care, everyone. We will be in recess until Thursday, 6 state all purpose calendar. Take care. Have a good day. Bye-bye.
Thank you.